Pokot South Member of Parliament David Kosing suffered a blow after the High Court dismissed his petition seeking to have NASA flag bearer Raila Odinga and his running mate Kalonzo Musyoka compelled to participate in the Thursday poll. While dismissing the petition, Justice Chacha Muita said the prayers sought by Kosing did not fall under the High Court's jurisdiction.
In conclusion, therefore, having given due consideration to this matter, I am not satisfied that it meets the threshold of a constitutional petition. The issues raised therein, though couched as constitutional questions, fall outside the mandate of this court. The upshot is that the petition dated the 2nd of October 2017 falls by the wayside and is dismissed with no order as to costs.
Justice Muita further ruled that no court can force anyone to participate in any election or political position, adding that the duo were within their rights when they withdrew their candidature.
I entirely agree with Leonard, a political choice to be made by the citizen. It is his basic right and fundamental freedom that cannot be enjoyed and exercised by, can only be enjoyed and exercised by the individual and not even the court, by an order of this court, can force or coerce one to exercise the right. That would in itself be a violation of that person's right to make a choice.
But the totality of the matter arising out of the decision of the High Court is this, that any issue regarding a presidential election or a presidential election petition is one that can be handled by the Supreme Court alone, and the High Court does not have jurisdiction on it. But more importantly is the issue that any candidate who seeks to withdraw from an election, be it presidential or any other election, cannot be compelled by the court in any manner whatsoever to participate in that election if he has made up his mind that he does not want to participate in that election.
That the issues of jurisdiction are normally raised at the beginning of a hearing. You can't allow a hearing to proceed. You will say, because I made an application to High Court on the basis that those are also fundamental rights, my own fundamental rights, and many Kenyans, including Mheshimiwa Jomo who is here. And therefore, procedurally and normally, you would expect that a judge will look at it and say, look, you know what, please can you then submit on the issue of jurisdiction. And then our legal counsels, or all the parties involved, would have then digested that idea and debated that idea of jurisdiction, and then we move to another place. But it cannot happen that you say, okay, well, you give hearing, everybody is given an opportunity to hear, and then at the tail end, you do your own research and say, you know what, this lacks jurisdiction.
Meanwhile, the High Court has dismissed a case in which activist Okia Omutata was seeking for establishment of a caretaker government. Justice John Mativo, in dismissing the petition on account of lack of jurisdiction, said that although the petitioner raises substantial issues, they did not fall within the jurisdiction of the High Court. It is now a matter of wait and see if the vocal human rights crusader will proceed to file another petition at the Supreme Court. Elsewhere, 3 voters have moved to the Supreme Court seeking to stop IBC from conducting the 26th October repeat poll. The 3, Helef Halif, Samuel Monochi, and Gashihi, attributed their decision to IBC's lack of preparedness and threats to its employees, which they argue may prejudice the outcome of the election. They claim that there exists active sabotage and frustration of the fresh election, and therefore IBC lacks the ability and capacity to conduct a free, fair, and credible poll. They further argued that the withdrawal of Raila Odinga and Kalonzo Musyoka triggered the vacation of the fresh presidential election by operation of law. Chief Justice David Maraga certified the application urgent and directed the petitioners to immediately file and serve their written submissions, as the matter will be heard Wednesday. And lawyers representing President Uhuru Kenyatta want the court to dismiss a petition by former Kilome Member of Parliament Harun Mwau seeking to stop fresh presidential elections on grounds that IBC did not conduct fresh nominations. Lawyer Fred Ngatia told the court that although nomination is a prerequisite for conducting an election where there is more than one candidate, the election should be left to proceed. He argued that disputes relating to a presidential election are within the mandate of the Supreme Court and should therefore not be litigated within the High Court's jurisdiction. Despite the government announcing Wednesday to be a public holiday, the court will remain operational in light of the ongoing cases related to the Thursday poll. Lilian Otieno for Channel 1 News.